Welcome to a new Title Talk series where we're breaking down a major change coming to our industry. Starting March 1st, 2026, a new change from FinCEN, the Financial Crimes Enforcement Network, goes into effect. It's a modification to a now nationwide anti-money laundering rule that will change how certain real estate transactions are documented and reported. It's big, it's detailed, and it affects buyers, sellers, and realtors across the country. But don't worry, we've got you. Before we dig in, if you like content like this, please support us by subscribing to our channel, hitting the like button, and clicking on the notification bell. In this 4-part series, we'll walk you through what the rule is, who it affects, what needs to be reported, and how it impacts your closing, clearly and simply. Let's dive right in. What is FinCEN and why it matters? FinCEN stands for the Financial Crimes Enforcement Network. It's a bureau of the U.S. Treasury, and its mission is to protect the financial system from abuse. They do this by collecting and analyzing financial transaction data to help law enforcement detect things like money laundering, tax fraud, terrorist financing, and more. What is the new anti-money laundering rule? Now FinCEN is turning its focus to real estate, specifically non-finance transfers of residential property. Yes, you heard it right, cash sales. The new nationwide anti-money laundering rule requires that certain transactions involving beneficiaries of trusts, LLCs, or other legal entities where no financing is involved be reported to FinCEN. This rule goes into effect March 1st, 2026, and it is not optional. It's the law. Finance transfers are not reportable under this new rule because they are subject to stricter regulation on the loan approval process. How is this different from before? A few years ago, FinCEN started implementing something similar through GTOs or geographic targeting orders. However, those were temporary, had price thresholds, and only applied in certain metro areas that had been identified as high risk. This new rule is permanent, does not have any price thresholds, and applies nationwide. Obviously, the scope is broader and the penalties are real. Why this matters now? This is one of the most significant compliance shifts we've seen in real estate in years. And if you're involved in residential transactions, even occasionally, you need to understand how this could affect your deals. Who will be affected? This rule targets non-finance transfers of residential real estate when there's no loan involved, and the buyer is a legal entity or trust. Whether you're a buyer purchasing through an entity or trust, a seller receiving an offer from one, or a realtor working with either party, this rule could apply to your transaction. What qualifies as a residential property transfer? Unfortunately, FinCEN defines this super broad. It includes houses, condos, co-ops, and even vacant land zoned for residential use. If it's 1 to 4 units and residential in nature, it likely qualifies. What qualifies as a legal entity buyer? Any LLC, corporation, partnership, or other entity created through estate filing qualifies. That includes shell companies and holding companies. Sole proprietorships and individuals buying in their own name are not subject to reporting under this rule. What about trusts? Trusts are also included. There are exceptions, and we'll cover those in the next section. What is a non-finance transfer? Quite simply, cash purchases, period. Regardless of whether they pay with different methods, such as wire transfers, checks, cryptocurrency, or even bartering. If there's no institutional financing and a legal entity or trust is buying, it likely needs to be reported. Reporting and responsibility. What are the reporting requirements? FinCEN is looking for us to report the beneficial owners of the entities. When a qualifying transfer occurs, specific information about the property and the individuals behind the legal entity or trust involved must be reported to FinCEN. For buyers and sellers, this means being prepared to provide accurate details about the ownership structure behind the purchasing entity or trust. And this is not optional and will delay your transaction if not provided timely. When does the report need to be filed? There is a strict 30 calendar day window after closing for the required information to be reported by the reporting party, or in our case, title company. That timeline matters because the necessary documentation must be gathered during the transaction, not a day later. What is reasonable reliance? FinCEN allows the reporting party to rely on information provided by others, as long as it's reasonable, documented, and credible. For buyers using an entity or trust, this means your information must be accurate and complete. For sellers and agents, it's important to understand that entity and ownership transparency is a key part of compliance. Exceptions, enforcements, and final wrap-up. Are there exceptions to the rule? Yes. If the buyer is a person acting in their own name, there's no reporting required. A buyer purchasing residential property as an individual is completely exempt. Some transactions involving government entities, regulated banks, or certain trusts may also be exempt, but always verify. What are the penalties for non-compliance? Failing to report, filing late, or submitting incorrect information can result in civil and even criminal penalties, including fines and legal action. This isn't just a paperwork issue, guys. This is federal regulation with real-life consequences. What if there are multiple legal entities? If multiple entities are involved in a transaction, all of them and the beneficial owners behind them must be disclosed. Transparency is key. How is the rule enforced? FinCEN has enforcement authority. They can review transaction data, investigate suspicious activity, and even refer cases to law enforcement agencies. How do I know if my transaction is reportable? If there's no financing, the buyer is using a legal entity or trust, and the property is residential, it's likely reportable. Quitclaim deeds also follow in the reporting cascade. So even if they're uninsured, be very wary of the transfers that may be reportable. When in doubt, ask early before assuming a transaction is exempt. And this wraps up our FinCEN series. We started with the big picture, what FinCEN is and why this new rule matters. Then we walk through who's affected, what kind of deals qualify, and what information needs to be provided. Finally, we cover the exceptions, the risks, and how enforcement works, so that you can feel confident heading into your next transaction. At Apple Tower, we believe compliance should feel clear, manageable, and well supported. If you have any questions about how this rule applies to your next deal, we're here to help. Drop a comment, send us a DM, or hit follow to stay in the know. Because in this business, the more you understand, the smoother you close. Thank you for watching and have a great day.